Hello everyone. Today I would like to share the patent administrative action in China with you. Allow me to introduce myself first. I'm Bo Xing, a lawyer and patent attorney with a focus on patent infringement cases and other intellectual property cases. I have participated in many patent cases, including patent infringement lawsuits and patent administrative actions. We hope this sharing would be helpful for your understanding of how the patent administrative action is working in China. We have three parts for this topic. The first part is an overview of the patent administrative action. We will see what is patent administrative action, and we are going to compare the patent infringement litigation and the patent administrative action. We will also talk about what kind of cases we recommend to find patent administrative action. And in the second part, we are going to discuss the proceedings of patent administrative action. In the third part, we will see some patent administrative action cases handled by our firm. Now the first part, and the first thing is what is patent administrative action? Well, it is a way to deal with patent infringement dispute using the power of administrative authority. You may know that for patent infringement, the right holder may file a lawsuit against the infringer before the court. The lawsuit is a strong legal action, which could put great pressure on the infringer. In China, for patent infringement dispute, alternatively, you may choose to file an administrative action before local RP office. The RP office will hear the case and make a determination if the patent infringement is established. If the infringement is established, the patent office will order the infringer to stop the patent infringement immediately. So both administrative action and lawsuit are the methods to deal with disputes using public power. Actually, patent administrative actions are more often adopted by the patentees in dealing with patent infringement dispute in Chinese practice. So now let's see comparison between patent administrative action and patent infringement litigation. Here we have a chart showing the number of the patent administrative actions and patent infringement litigations from 2019 to 2023. We can see that the patent administrative actions are more often adopted by the patentees in dealing with patent infringement and Chinese practice, and the number of both actions is growing. To have a clear view, let's compare patent infringement litigation and patent administrative action in these aspects. Please have a quick review. For the first aspect, organization and person making the decision, according to our experience, usually the judge is more experienced than the officer of IP office. So for complex patent infringement cases, it is advisable to file an infringement lawsuit. When the infringement situation is not so complex, patent administrative action may also be considered. For the claims, in the litigation, the plaintiff could claim injunction and damages. However, in the administrative action, the applicant could only claim injunction, and generally, no damages can be obtained through administrative action. However, if the parties reach a settlement, it is possible for the patentee to obtain some monetary compensation from the infringer. In one of the administrative actions handled by our firm, the patentee obtained more than $42,000 from the infringer after signing a settlement agreement. We will talk about this case in more details in the following part. An obvious advantage for patent administrative action is that the patentee could get a very quick injunction, and after the decision is made by the IP office, if the applicant still wishes to claim damages, a patent infringement lawsuit could be filed. And after the decision is made by the IP office, if the applicant still wishes to claim damages, a patent infringement lawsuit could be filed. Next, normally in a lawsuit, the court will not conduct an on-site investigation against the infringer. In some cases, the plaintiff may request the court to conduct evidence preservation, and if it is approved by the court, the judge may go to the defendant's factory to conduct evidence preservation. In administrative action, generally officers are possible to enter into the factory of accused infringer to get evidence. Generally, it is easier to apply for on-site investigation in administrative action than apply for evidence preservation in a patent litigation. In litigation, the court will review the request of the plaintiff for evidence preservation and then decide whether to approve the request, and the plaintiff should pay bond to the court. In the administrative action, in most cases, the officer will conduct on-site investigation and no bond needs to be paid. Next, suspension. When the plaintiff files a patent infringement litigation as a countermeasure, the defendant could file an invalidation request against the patent involved, and in an administrative action, the adversary is likely to take the same countermeasure. If the invalidation request is filed in a lawsuit, the possibility is low for the court to suspend the proceeding. More specifically, when it comes to an invention patent that is involved in the case, generally the court will not suspend the case, even there is an ongoing invalidation, since an invention patent has gone through substantive examination, and the patent right is relatively stable. When it comes to utility model and design patent, there is a high possibility the court will suspend the litigation and wait for the invalidation decision. These two types of patent are granted after formal examination, and there is no substantive examination, and the patent right is not as stable as an invention patent. The situation of suspension is different in an administrative action. Generally, the IP office will suspend the case when there is an ongoing invalidation request against the patent involved in the case, no matter it is an invention patent or utility model or design patent. To give you a more specific picture, for all the patent administrative actions handled by our firm, the IP office suspended the proceeding after the respondent filed an invalidation request. For the time limit, Chinese law provides that the first instance of a lawsuit should be concluded within 6 months. However, in practice, generally it takes 1 to 2 years for the court to make the first instance judgment when a foreign party is involved, and since Chinese courts has a large amount of caseload. Then, the administrative action takes less time, usually 3 to 4 months. As to means of relief, the party may file an appeal when it is unsatisfied to the first instance judgment. The second instance judgment is final in China. For patent administrative action, the party may file an administrative lawsuit against the decision. The administrative lawsuit is an independent action, and additional cost will incur. What is worthy to notice is that during the administrative lawsuit, the enforcement of the decision made by the patent office will not be stopped. That is to say, if the decision determines the infringement is established and requests the infringer to stop the infringement, the sanction of the infringement will be valid during the administrative lawsuit. For the official fee, the court fee is based on damages requested, and the standard is same all over China. And if the plaintiff wins the lawsuit, the court may order the defendant to bear the court fee, in part or entirely. The standard of the official fee of an administrative action may vary in different places, usually from 0 to 2,000 RMB per case. Here we made a summary of cases that patent administrative actions are recommended. Under these circumstances, the patentees may consider filing patent administrative action. First, when the infringement is obvious and it is easy for the IP office to determine infringement. Second, when the main purpose of the patentee is to get a quick injunction. The right holder may file a civil lawsuit to claim damages after receiving a favorable decision. Third, when the suspected infringing product is a large machine or some B2B products that are difficult to be preserved as infringement evidence before filing a lawsuit. Filing patent administrative action may be a good option for the purpose of obtaining infringement evidence. Through the on-site investigation of the IP office, strong infringement evidence may be collected, which could be used in litigation. Now, let's move to the second part, proceedings of the patent administrative action. Here is a flow chart. There are mainly 4 steps for the action. First step, filing and accepting. The applicant files the complaint. The IP office will review the documents and then accept the cases. For the documents required for the administrative action, there are 3 main parts: entrustment documents, ownership evidence, and infringement evidence. For the infringement evidence, the preliminary evidence is sufficient. For example, the screenshot of the accused infringer's website showing the picture of the suspected infringing products is sufficient. By the way, administrative action and patent infringement lawsuit could not be adopted simultaneously to solve the dispute. If the right holder wishes to take administrative action, it shall notify a patent infringement lawsuit at the same time. Usually, the IP office will request the right holder to submit a written understanding that he will notify a parallel patent infringement lawsuit. And the second step, the IP office will serve the relevant documents to the accused infringer. Normally, the officer will conduct an on-site investigation against the infringer. Here are some photos of the accused infringing products in the on-site investigation. The officer will not have the accused infringing product sealed or detained in the investigation, but the quantity of the product could be recorded, and the officer may take some samples of the infringing products. The pictures and the samples of the infringing products could be strong infringement evidence, either in the administrative action or in a patent infringement lawsuit, if later the right holder wishes to take such an action after the administrative action is concluded. Third step, the accused infringer may make a response, and the IP office will organize an oral hearing. In the hearing, both parties may express their opinions. Usually, the IP office will organize a mediation between the parties, and the settlement may be reached. And if the settlement is not reached, the IP office will make a decision. Here we have a flowchart showing each step of the patent administrative action and various circumstances with time limit for each step. If the purpose to file the administrative action is to obtain infringement evidence, after the purpose is achieved, for example, after the on-site investigation or after the respondent makes a response, the right holder may withdraw the administrative action and then file a civil lawsuit. This slide also indicates that after the decision is made, if a party is unsatisfied with the decision, it may file an administrative lawsuit against the decision. So now let's move to the final part, some cases handled by our firm. Our firm has handled dozens of patent administrative action cases, and 3 of them have been selected as top 10 cases of CNIPA or Guangdong Province. Today, we would like to have 5 cases here, and each of these cases have its own highlights. The case 1 was concluded within 1 month, much faster than litigation. During the mediation of the local RB office, the infringer stopped infringement and agreed to pay 300,000 RMB as compensation. The client achieved its purpose quickly and also obtained a settlement fee. The client was very satisfied with the effect of the administrative actions, and after this case, it usually prefers to take administrative actions first, and then consider filing litigation to claim compensation after the decision, if no settlement fee is achieved during the administrative action. The case 2 is representing Panasonic, and through the administrative action, the infringer stopped the infringement. So we can see Panasonic, a large transnational corporation, also chose to file administrative action to solve patent infringement dispute in China. I will introduce the case 3, 4, and 5 to you in details. For case 3, the infringing product is gacha machine. You put a coin and twist the button, and you will get a capsule toy. In this case, the infringer imitated the client's machine in several ways, and a serious infringement is involved. The invention patent infringement, imitation of trademark, imitation of domain name, imitation of the appearance of the machine. Based on the situation of this case, we recommended the client to file administrative actions against the infringer. There are 3 patents involved, and the client files 3 administrative actions at the same time to put pressure on the infringer. For your information, one administrative action could only involve 1 patent. If there are 3 patents involved, 3 actions should be filed. And in the on-site investigation, a sample of the infringing machine is obtained. In the oral hearing, the officer organized a mediation between the client and the infringer, and finally, the settlement is reached. The client did not request the infringer to pay settlement fee. In exchange, the infringer agreed to stop all the infringement, the invention infringement, the imitation of the trademark, domain name, and the appearance of the machine. The settlement agreement also stipulated a high liquidated damages. If the adversary party infringes again, it needs to pay a high liquidated damages. So in this case, through the administrative action, a series of infringement was settled together, and the client is satisfied with the results. Next, the case 4. The infringing products in this case are the mini printers in POS machine. The POS machine is the end product. In this case, the infringer, the Xiamen company, infringed a design patent of the client. The client has filed a design patent infringement lawsuit against the Xiamen company and won the case. However, the Xiamen company did not stop the infringement after the lawsuit. It is predictable that the Xiamen company is very alert, as have been sued once. The former law firm entrusted by the client tried several methods, but could not obtain the evidence of the continued infringement. Then the client transferred the case to our firm. We reviewed all the information of the case and provided a strategy to the client. Firstly, we purchased the end product, the POS machine, with the infringing product. Our patent attorney took apart the POS machine and took out the infringing product. The appearance is identical to the former infringing product, and the model name is similar. But there is no logo or company name on the infringing product. it may not be sufficient to prove that the manufacturer of the infringing product. Then, we use the POS machine as evidence to file an administrative action against the Xiamen company, explaining there is a high possibility that the company was still manufacturing the infringing product, requesting the officer to conduct on-site investigation. Local RP office accepted our request, but unfortunately, the identical infringing product was not found in the factory. The officer found another similar product and took some samples. We claimed the similar products also infringing the patent, and RP office agreed our opinion and made a decision that the samples found in Xiamen Company's factory constitute infringement. Also, the officer demanded and obtained manufacturer information of the infringing product from the POS machine producer, which was recorded in the case file. Such information became the key evidence for the repeated infringement of Xiamen Company. We used above evidence obtained during the administrative actions, and in the litigation, the court awarded punitive damages. So let's move to the case 5. The infringing product in this case is consumable lamp in machine. The lamp is used on a large machine and is consumable. To save cost, the buyer of the machine purchased the infringing product from the infringer. The infringing product, the lamp, is B2B product, and we found that it is only supplied to one company, the buyer of the machine, so we could not purchase the infringing product from the market. We also tried to arrange an investigator of the investigation company to enter the factory to obtain a product. However, the infringer is very alert and it failed. Based on the situation, we suggested the client to file an administrative action against the infringer. During the on-site investigation of the administrative action, the officer takes several samples from the factory of accused infringer. Then we file a civil lawsuit, using the samples obtained in the administrative action as infringement evidence. This is a typical case to show that the administrative action could be used as a method to collect infringement evidence. So that's all my sharing today. I listed the merits and demerits of the patent administrative action in this slide. If there is any patent infringement dispute in China, the client may choose to file a patent administrative action or file a lawsuit based on the specific situation. Of course, we are glad to provide an advice for this regard. If you have any questions for this topic or the enforcement of RPA rights in China, you may send an email to our forum, and we are glad to provide our suggestions. Thanks for listening.